Hello everyone and welcome to our lecture recording for chapter 9. Today we're going to continue with contracts and the intention to create legal relations. So we're basically looking at the second element of the analysis on the existence of contracts. In chapter 8 we looked at agreement. Today we're going to look at intention, and in the next lecture we're going to look at the third element, which is consideration. As usual, we're going to go through the chapter using the learning objectives, and for chapter 9 the learning objectives are on page 239, and the first asks us to explain the difficulties in determining an intention to create legal relations. Now, this is available for you on page 140, and the difficulty is explained as follows. So we are really trying to work out what the parties to the agreement intended should be done if and when things went wrong. And in trying to find an answer to this question, the question of intention, the courts have classified agreements into two categories. Okay. The thing is that usually parties don't make express references to the question of intention, meaning that if you go looking for an express statement of the intention of one of the parties or the other, more likely than not you will not find that in any of the things that were done between the parties, or in the correspondences, or the meeting minutes and so on. So it's only when a problem arises between the parties that intention suddenly becomes an issue. So the courts, in order to try to ascertain what that intention was prior to getting to that point where there is a contention or there's an issue, as we said, the courts have classified agreements into two categories, but we will look at something called the case of Hermogenes, which is a High Court of Australia decision from 2002 that modified a little bit the approach that we have in relation to these presumptions. Now remember that you have to distinguish also between what we call a presumption and what we call a deeming. If we say something is presumed, then we always keep the door open for a rebuttal, so you can always rebut the presumption. If we talk about something as being deemed to be something, then you cannot rebut that. It's not a presumption, it's a deeming, it's not something that we can rebut. But today we're talking about presumptions, and we're talking about two presumptions: agreements of a social or domestic nature, and here there's a rebuttal presumption that the parties do not intend legal relations. And the second category is where agreements of a business or commercial nature, and again there's a rebuttable presumption that unless the contrary can be established, it's presumed that the parties did intend to create and enforce contracts. We'll talk about that in more detail in a minute. But the key point is that there is a difficulty in determining what an intention is, because people don't usually express their intention in a way that is easily ascertained. So they might have an intention, but that intention is not something that's expressly stated. So we have to go look at it through other means, and these means usually are these categories of presumptions we've just spoken about. There's also this case of Hermogenes, and basically that case suggested that applying presumptions, these two presumptions, is no longer the appropriate test for determining intention. Okay, so intention is now determined by considering the relevant context and the relationship between the parties, and determining what inferences can be drawn from that. So that's what Hermogenes said. However, keep in mind that the traditional characterization of arrangements between the parties as social or as commercial would still be a useful starting point, okay, as a starting point for understanding how the courts approach the issue of determining or the determination of intention, but it's not the last thing that we have to do. We need to move beyond that and look at the factual matrix and the contextual facts and the relationship between the parties. All right. Now, just one point quickly. At the bottom here, we say that if there's no intention, there's no contract. Okay. Now, remember that when we say that there are three elements to the existence of a contract, that simply means that all of these elements are necessary. They are all necessary. You have to have all three elements in order for you to later then come to the conclusion that there is a contract, that a contract exists. So if you miss one of these elements, we're talking about, of course, the element of agreement, intention, and consideration. And consideration we'll be talking about next time. But for today, we're saying if you miss intention, which is one of the elements, then of course there would be no contract. Same applies to agreement and consideration. So if there's no agreement, there's no contract. If there's no consideration, there's no contract. Okay. So let's then move on to the next learning objective that asks us to explain the requirements for parties to show their legal intention in contracts. So we start this point, really, we have already started on it, but we start this point from page 241, this learning objective from point 241. And we're going to talk about intention generally. So again, for an agreement to be legally enforceable as a contract, one of the conditions that must be satisfied is that the parties intend to create legal relations. Intention, however, can be express, which is rare. So it's expressed in terms of words or writing or conduct, or it could be implied. Okay, and we'll talk more about how intention could be implied. But if it's not present, if intention is not present, there can be no contract again. All right. Implied intention then, okay, can be obtained from the two presumptions we've spoken about earlier. And these are looked at in some more detail on page 243. And again, we have these two presumptions, one for social agreements and one for business agreements. Okay. So these were basically rebuttal presumptions of fact. There was an objective test that would apply, and we can see that on page 244 in figure 9.1. So it says, if you have social or family domestic or even voluntary agreements, then there's a weak presumption, which means that it could be rebutted easier, that the parties don't intend to create legal relations. Parties do not intend to create legal relations. Okay. But there's also the other rebuttal presumption of commercial or business agreements. This is a strong presumption that the parties intend to create legal relations, which means that it's more difficult to rebut. It's more difficult to prove otherwise. I've already spoken about Hermogenes and the idea that they could have spiritual relationship, but that spiritual relationship could still be legally enforceable. We can see more uh, about Hermogenes on page 240, but it also takes us to page 252. Okay, and that there gives us a more idea about this thing with spiritual relationship that could still be legally enforceable. Okay, so the bottom line or the takeaway point is that each case, okay, the context, each case must be treated on its own merits. All right. Let's then move on to our third objective, and we here distinguish again the social agreements and discuss the presumptions attached to these agreements. So there are other, of course, non-commercial agreements. So these all start on page 245, and we can find there social agreements, domestic agreements, and voluntary agreements. The key point in relation to all of them really is that as a general rule, okay, there will be no difficulty in inferring that the parties never intended to create legal relations when you have these contexts, when you have these types of agreements. So again, we have two types of agreements. Even after Hermogenes, we take these as our starting point. And these types of agreements talk about social agreements and business agreements. And the social agreements, like the ones we just mentioned, but also including things like domestic, family or domestic agreements and voluntary agreements, these are all really, there's a weak presumption that they are the parties in such agreement, the parties to such agreements do not intend to create legal relations. In contrast, if it's a business agreement, there's a strong presumption that they do, that they intend to create legal relations. All right. Now, how do you rebut these presumptions? Rebutting the presumptions again is on page is on figure 9.2, and that's on page 244. That talks about how you rebut the presumptions. Okay. So as we said, if it's a social agreement, there's a weak presumption, and it's the onus on the plaintiff to rebut and show contract was intended. And if it's a commercial agreement, the onus is on the defendant to rebut and show the onus was not intended. Okay. So we look at things like, this is an objective test, which means it looks at the reasonable person. So on a reasonable person, if the reasonable person looks at what the agreement says and what the parties have said and the conduct of the parties and the consequences for the parties and the surrounding circumstances, if a reasonable person looks at all of that, would they then decide that the presumption, whether the weak presumption or the strong presumption, should be rebutted or not? Now, there are matters that the courts take into account when determining intention to create legal relations. Okay, so these are also given to you on page 244. So in relation to the question of whether the parties could objectively be seen to intend to create legal relations, matters could be taken into consideration that include things like the subject matter or topic of the agreement, the status of the parties and the relationship to one another, whether there is a consensus among the contracting parties, and the extent to which it's expressed to be finally definitive of their concurrence, and the way it came into existence. Also, we take things into account such as subsequent conduct or communications between the parties and any other surrounding circumstances. Note the point on page 245 at the top says, although this approach does not involve characterization of the agreement or a matter of presumption, in a large number of cases the results will be the same if the agreement had been characterized as social or as business and the presumptions had applied. Okay, so there's not much difference between these two approaches in relation again to the Hermogenes approach of taking the context into consideration and the presumptions that we take still as starting point. Okay, so this is again a rundown of the difference that Hermogenes said, okay, before Irmogeneous, the three types of agreements were identified as lacking serious intention, and we talked about social agreements, and there are also things like lotteries and competition. So if we look more into in detail at the category of these social agreements, you'll find that there are circumstances, for example, where there are lotteries and competitions, and this is detailed, given in some more detail on page 246 in the discussion of the Trevi and Grubb Trevi and Grubb case from 1982. And there are also agreements between domestic partners, which is explained in more detail on page 247. Okay. I'll leave that really for you to go through, and we'll continue then with voluntary agreements. Again, this is one of the three categories that the weak presumption applies to. So the voluntary agreements are given to us on page 250, and basically there is that business tip there that says before a person volunteers their services, they should inquire whether they are entitled to workers' compensation. Usually they are not, they are rather not considered to be an employee, and therefore there's no contract of employment. Okay, so if they are injured on the job, they will not be eligible for workers' compensation, and this is available only to employees. And you'll see a case in point on page 251 in relation to Teen Ranch and Brown, the case there that talks about these issues in relation to volunteering. Okay. All right, we'll leave it there, and we'll move on then to our non-commercial agreements, relevant factors in determining intention in non-commercial agreements. And we did already talk about this in some detail, but you also find these in an in brief box on page 252, which says that you could also take into account the type of the relationship, the degree of closeness of the relationship, the nature of the relationship at the time of the alleged agreement, the intention of both parties, and whether there is a consensus among the contracting parties, the extent to which it is expressed to be finally definitive of their concurrence, the subject matter or topic of the agreement, the way it came to existence, the seriousness of the conduct involved, whether there is any expense, inconvenience, or substantial detriment involved, whether litigation was contemplated, and whether the agreement was formal or informal. So in a nutshell, again, to go back to our point, when we talk about establishing the intention, in order for us to establish whether a contract exists, we need to establish whether there was intention to create a legally binding relationship. Now remember that we also talked about intention, if only briefly, when we looked at the idea of establishing agreements, and especially the traditional approach of establishing agreements in terms of what an offer is. And we looked at offers, and we saw that there was a conventional approach, rules relating to offer, and one of them, the first one, was an intention or willingness to be bound. So you'll find that this idea of intention, of this requirement of intention, flows through the first element of agreement and the second element in relation to intention to be legally bound. You'll find that in order for us to establish agreement, we still have to be able to find that there was intention to be bound, and that comes through really the way the offer and the details in the offer and the way the offer was made. Okay, but there are also other indicia, if you like, of intention when we come to the relevant factors we just talked about on page 252. But there's also a starting point for our analysis under intention, where we look at the presumptions. So we ask ourselves, are we looking at something that's a social arrangement or a business arrangement? And if it's a social arrangement, we'd say that there's a presumption, a weak presumption, but still a presumption that there is an intention not to be legally bound. Okay, so we don't really have a contract. And if it is a business arrangement, then we start with the presumption, the strong presumption, that the parties actually intended to be legally bound. Okay, and we take it from there and start looking at other factors and the context within which things happened under the homogeneous approach to really ascertain whether there was really intention or no intention. So we're really talking now about rebutting these presumptions. Okay, rebutting the weak presumption under the social arrangements and the strong presumption under business arrangements. The weak presumption under social arrangements again is that there is no intention to be legally bound, and under the strong presumption for business arrangements that there is a presumption to be legally bound. Okay. Let's then move on to our fourth learning objective, which asks us to move to the next category, which is the commercial and business agreements. So we want to identify and explain the legal presumptions that apply to these agreements. We've already talked about them in terms of the presumptions, but we carry on with the discussion from page 253 onwards. And again, there's a strong inference that the parties intended to create legal contractual relations in terms or in contexts or in situations where there is a business agreement. Now there's a business tip on page 254 that says letters of intent on their own are not conclusive evidence that the parties intend to contract. Sometimes people sign letters of intent that they want to do something, but that is not in itself conclusive evidence that the parties intended to contract. So we're talking now about a business arrangement, and people sometimes write these letters of intent and they sign them and they explain basically what they're planning to do, but that does not necessarily mean that they are gonna that they have intended by signing these letters that they have intended to enter into contract. So as it says in the business tip again on page 254, at best they may be evidence of an oral contract, such letters of intent. Okay, but to avoid the type of problems arising that arose in the case that you see on the previous page, which is PERT Biotechnologies, on page 253, says all of the parties to negotiations should ensure that at each stage in the negotiations or the negotiating process they understand and agree on what their current status is. Okay, so if you are in negotiation, you have to be very careful not to give the impression that you have already agreed to enter into contract, but rather that you are intending to look at the possibility of entering into contract and make that very clear to the other party. Otherwise they might think that you are actually agreeing to entering into a contract already. Okay, now again on page 254 it says while there is initially a strong inference that legal relations are intended in commercial arrangements, the courts will accept that the parties did not intend to create legal relations, i.e. rebut the presumption, if they use clear wording to that effect. And they will give an example, wording such as this agreement is subject to contract, okay, subject to the preparation of a contract of sale which shall be acceptable to my solicitor. That's another example. Okay, binding in honor only, or things like shall not be attended by or give rise to any legal relationships. Okay, so the key point, you have to be careful to make clear what your intention is, especially in a negotiations phase or a negotiating process. Now, there's something very quickly about letters of comfort. Letters of comfort on page 254, and it talks about really in order to secure a loan, a bank or lending institution will try to seek a guarantee. Okay, this is about a guarantee from a parent company and if possible from the subsidiary company to whom the loan is made. Okay, so this is the only way in which the lender can be certain that assets of the group will be available to meet the obligations of the borrower should there be a default on the loan. So if you are going to give money to a subsidiary, you want to make sure that there is this letter of comfort coming from the parent, or basically you want a guarantee rather from the parent company that if this subsidiary fails to pay back the loan, the parent company will pay it for you. Okay, they will step in and pay for the subsidiary. Now, where the loan rather is supported by a contract of guarantee, So if the parent company agrees to give you this contract of guarantee, then there's no problem with intention. The problem though is happens when the parent company refuses to give you this contract of guarantee. Okay, for example, because it doesn't want a contingent liability to show up on its balance sheet. So if you've done some accounting, you'll know that these loans will show up on your balance sheet and they will be part of the liabilities that you are open to, and that means that it will change your performance ratios, for example, which is something that of course the parent company wouldn't want to do, or it might just not want to be a guarantor. Simply they just don't want to guarantee the subsidiary. In such cases then a compromise is known as a letter of comfort. Okay, so it may take the form of an undertaking to maintain its financial commitment in the subsidiary, or it may be a letter of comfort where the parent company agrees to use its influence to ensure the subsidiary meets its obligations. Okay, so in the case of a guarantee, the liability of the guarantor arises on default of the subsidiary. The problem with the letter of comfort though is that it may be difficult to ascertain whether it's intended to have a legal effect. That's the problem. Okay, and you are given examples from cases on page 255. So there's an example from the Kleinwert Benson and the Malaysian Mining Corporation, and then contrast that with the Bank Bruxelles Lambert and the Australian National Industries case on the same page. Alright, there's also this point about government contracts at the bottom of page 255. So while governments and government departments enter into contracts on a daily basis, there are some types of government dealings that simply don't result in the creation of contractual relations. So types of government dealings that do not result in contractual relations. Okay, these usually involve some aspects of the government's political or administrative activities, and the courts are more reluctant to infer an intention to create legal relations. Okay, so for example, where government schemes or handouts are concerned, okay, and there's a case in point there, the better view is that there is no intention to create legal relations, and you can look at that case on page 256. There's also the point about advertisements. So we talked about advertisements previously when we contrasted offers with things that are simply invitations to treat. So again, where advertisements are concerned, it's presumed, okay, that they are not intended to create legal relations. The presumption there is that they are not intended. As usual, each case should be looked at on its facts to see whether intention is present. So thus, the use of expressions such as one per customer or rain check by advertiser in a newspaper advertisement or brochure is making it clear that the world at large, making it clear to the world at large that if they run out of a product, they will get more in at the advertised price for the customer. In other words, there is an intention on the part of the advertiser to be bound. Okay, so the key point again to emphasize from our previous discussion with offer is that you have to look at each case by itself, but the general presumption, the presumption rather, is that, or the general rule if you like, is that the advertisement or advertisements generally are not offers. Okay, there's no intention to be bound. Remember that. Again, I refer you to the previous chapter 8, and in particular to the inbox on the rules relating to offer, which is on page 211, and it says specifically there that in order for us to determine whether there's a valid offer, there has to be an intention to be bound. Okay, so this is the same idea. If it's an advertisement, usually there is no intention to be bound. That's the presumption we start with, but sometimes you could find that that's not the case. And if you go back again and look at page 213, the Pharmaceutical Society of Great Britain and Boots case, the Boots case on page 213, you'll find that that was simply an sorry, that's not the case we're looking for. We're looking for the case in relation to advertisement, and that's the Carlyle and Carbolic smoke ball on page 220. So this is the Carbolic or the Carlyle or Carlyle case on page 220. Look at that case and you'll find that there is an advertisement there, but that advertisement, because we have to look at all the facts and we look at each case by itself, each situation, so something very similar to the homogeneous approach under intention. And we found that there were facts in this case that indicated that in fact there was really intention to be legally bound, and because of that we found that even though it's an advertisement, that advertisement would qualify as an offer, and if it's accepted then we have a valid contract. Okay. And the same thing of course is repeated for you on page 256, the Carlyle or Khalil case on page 256, specifically in relation to this point in, as to advertisements. Now there's also some talk about the statutory position, okay, in relation to misleading conduct or representations under the ACL, which is of course the second schedule, as we said, of the Competition and Consumer Act of 2010. Again, the business tip at the bottom of page 257, it says in the case of advertisements, it's presumed that there's no intention to create legal relations, but advertisers should make it clear that the advertisement in the advertisement if restrictions are to apply to avoid a breach of federal or state consumer protection legislation. For example, in the advertisement, use wording such as subject to seat or room availability. Similarly, the use of expressions such as one per customer or rain check make it clear to the world at large that the advertiser intends the consumer to get the product at the advertised price if it runs out. Alright, so that's then the lecture for today, and this was our second element, intention, under the question of whether a contract exists or not. So we said we have to establish three elements. First one was agreement under chapter 8, and then intention under chapter 9, and then next time we'll have consideration under chapter 10. So we'll continue again with this question of the existence of a contract, and that will be our lecture recording for next time. Bye for now.